We're continuing our partnership with Learn Liberty this week, and joining me is author of Unwanted Advances, Sexual Paranoia Comes to Campus, as well as a professor in the Department of Radio, Television, and Film at Northwestern University. Laura Kipnis, welcome to the Rubin Report.
Thank you. Hi.
Hi. I have had roughly, if I had to add it all up, a gajillion requests to have you on.
Oh, great.
So I feel like we're going to clean up a lot of stuff here related
Let's try.
Yeah, related to Title IX. I did my little direct message, my preamble, sort of giving a vague explanation of Title IX. You sort of got in the mix on this thing when you wrote a piece in the Chronicles of Higher Education in 2015, which I want to get to that and your whole story related to all of that. But first I thought, could you just give me a basic explanation of what Title IX is and then how it changed during the Obama administration?
Okay, I should start out and say that it was never my goal in life to become an expert on Title IX, but as you might have said in the intro, I was brought up on Title IX complaints, and at the time I had no idea what this was. You know, I thought it had something to do with women's sports. So the brief backstory is that in 2011, the Department of Education under Obama expanded Title IX, which had covered gender equity in higher education, meaning like equal funding for sports teams and that sort of thing. And they expanded it to include sexual misconduct, because the idea was that you can't have gender equity if students, particularly women students, are, you know, fearful for their safety or are being assaulted, you know, or harassed or that kind of thing. So, you know, it's a good goal. But they issued these things called Dear Colleague letters that were guidance to institutions of higher learning that got federal funding, and threatened that if the schools didn't comply with these very vague guidelines, that their federal funding could be withdrawn. And, you know, most schools get, you know, tons of their funding from the government in research grants and that kind of thing. So all campuses were required to have Title IX offices and officers and implement this guidance, and it had to do with creating processes for sexual misconduct complaints, but also it dictated things like the standard of proof that would have to be used in these adjudications. And the standard was what's called preponderance of evidence. And that's a hugely controversial thing, because what it basically means is 50-50 plus a feather. And the process also has been, I mean, as I learned having gone through it, behind closed doors. So none of this is out in the open or transparent, and so you have more and more people getting caught up in these sort of kangaroo court situations, both undergrads, mostly male students, who get accused of having non-consensual sex, usually in drunken, you know, sexual encounters that somebody later decides was not consensual, but also professors increasingly. So what happened was, after I got brought up on these complaints, I wrote a second article, and I got brought up for writing an essay about you know, the kind of increasing vulnerability of students, and it was called Sexual Paranoia Comes to Academe.
Yeah, I think maybe we should pause there for a second, because you gave me a lot there, so let's just whittle away some of that.
All right.
So first off, I think a certain amount of people would be listening to this and thinking, wait a minute, how can a university lower the expectation of what evidence is to prove someone guilty of something? If it's supposed to be you're innocent until proven guilty, how can a university have a expectation that's lower than that? How does that even make sense? I mean, what's the actual rationale there?
Well, the rationale is that they're following this federal guidance, but you know what happens.
But the federal guidance seems to be in conflict with the Constitution, no?
Well, so one of the things I learned is you don't actually have constitutional rights at a private university. So there's how this stuff is handled differs between public institutions and private schools. And private schools can do what they want. So they're in a more contractual relation with students. And you know, a lot of the information on this is only coming out because these cases are going to civil court. So like students who've been accused and think they've been railroaded are suing the schools, and that's how we learn what's going on. Otherwise, nobody would know.
So in effect, these edicts come through from the administration. It's you know, now the burden of evidence is suddenly on the accused in a bizarre way, and it really never bubbled up until some of the men in this case started taking civil action because they were either falsely accused or they felt that they were falsely accused or wanted to fight.
Yeah, or there are no standards of evidence. And so that was the kind of thing I learned from going through the process. So I was accused of, say, creating a hostile environment. And I said to the Title IX investigators, how do you know? I mean, or I was creating a chilling effect on the student body. And I said,
wait, we should explain that though. So your 2015 article, let's just explain what that was and how it got you into hot water before we jump too far ahead.
I wrote an article called "Sexual Paranoia Strikes Academe" for the Chronicle of Higher Education, because they asked me to write something about campus sexual politics, because I was known, I guess have been known as something of maybe a contrarian feminist, and I've written about sexual politics a lot. So I said, okay. And I kind of thought nobody read the Chronicle of Higher Education, and so I wrote in a kind of ironic, maybe, I had some fun with it, and I do lean toward irony. And so first there was a protest march on campus by students carrying mattresses and pillows, like a reference to the Columbia student, accusing me of fostering or supporting rape culture, I guess. And then found out I was brought up on these Title IX complaints, but so I never found out precisely what I was charged with, because there isn't such a thing as due process in these situations.
Right, so to be clear, you write this piece, and as you're saying, it was kind of tongue-in-cheek, but with the expertise that you have.
I mean, serious, but with an ironic tone, I would say.
Yeah. So you write this piece, and then you're brought up on these charges.
Yes.
But what does you writing this piece have to do with anything? How does that even become within the jurisdiction of Title IX?
Well, it should not have been, and so it is a question mark why the university allowed the case to go forward, because there is some sort of provision in the Dear Colleague letter that says nothing here should be construed to impinge on freedom of speech or academic freedom, but nevertheless, I mean, what's happened is what you would call mission creep in these situations, where the code has been stretched to include such things as writing an essay, and as I later found out, I mean, all sorts of kind of micro behaviors that somebody might take offense at. So in my case, I had written a couple of paragraphs about another professor on the campus, so I didn't know, but it was public information that he'd been accused of sexual misconduct. So I made reference to that case. So I was accused of retaliating, which is a big thing in Title IX. Mostly people cannot speak about the charges against them, because if they speak about them, they might be brought up on more complaints for retaliating. So I was charged with retaliation, even though I wasn't the person who'd been involved in the sexual misconduct to begin with.
Right, and to be clear, so the person that was accused of this, who was a colleague of yours, although you did not know him, he was accused of having relations with a student, but consensual, if I'm not mistaken, right?
There were two sets of complaints, and one was that he'd gone out drinking with a student one night, and they ended up sleeping in the same bed, but they didn't have sex. There was no indication that they'd had sex, but he was accused of possibly having come on to her. He bought her drinks. And then there was a second situation, which I actually did not write about, where he'd had a relationship with a student. So I wrote about 7 or 8 words about that second relationship, and that was, I think, the basis of the complaints, that I'd made reference to this situation.
That in effect they felt you were defending him, correct?
I suppose so. I can't say what anybody thought or felt, really, right?
I guess you can, but I think we can surmise that that's what they thought that you were doing. But your feelings on that specific matter, outside of Title IX, really, is that if they're consenting adults, whether he's a professor and she's a student, that you're okay with that, basically, right?
In the first essay, I was somewhat mocking these new regulations that govern professor-student dating, that prohibited it, particularly in the case of undergrads. It was sort of okay if you're a grad student, but frowned on. And one of the things I was saying was that, you can look around any campus on the country, you can barely throw a stone without hitting a couple, a married couple, often with children, that started out as a professor-student situation. And it's widely known in academia that, some percentage of your colleagues are married to former students. Mm-hmm. So it seemed a bit hypocritical to suddenly enact these codes that would regard those situations as like close to some sort of predator. So I felt that the professoriate was almost being regarded as predators in waiting, and that dating was ruled out. And I don't want to sound like some old geezer, but when I went to school back in the good old days, I mean, we did all sorts of stuff. We partied and drank with professors. It was no big deal. People were sleeping with professors all over the place. So this new climate of regulation was something I wanted to write about from a somewhat skeptical vantage point.
So in your mind, it really was about the regulation that they were putting on. Not you weren't specifically defending or not defending the actions of this guy, which I think is sort of where it got turned a little bit against you.
Yeah.
So I think that's interesting.
I mean, the version of feminism that I would subscribe to would see this climate of regulation as not in the spirit of feminism, and I think I've used the term feminist paternalism. But I will say what happened was that, or maybe we'll get to this, I mean, I ended up learning more about the situation with this professor and writing more about it in this book. So there's a couple of chapters about these two cases against the professor where I do a close reading of the Title IX reports, which I ended up having access to. And so that was very informative.
All right, so we will get to that for sure, because I think that'll sort of bring this all together.
Okay.
But okay, so now you're brought up on these charges. Mm-hmm. What was that like for you? I mean, literally, you're a professor and an author, and you wrote an article.
Yeah, yeah.
You're using words, and now you're brought up on charges from the government.
Yeah, well, from my institution, but
right, from your institution.
Yeah,
right.
I mean, I was very much in the dark. I knew nothing about Title IX, and they send you like a letter with all these links to various, informational websites, and every website has more links and more links, and it's like a rabbit hole of hyperlinks that you learn nothing from. Like, I did not learn how I could be charged with retaliation for writing about someone else's situation. So it's very mystifying. The procedures, and what I've learned in these cases, when you're accused of something, for the most part, you don't find out what you're accused of. You don't know what the evidence is. You often don't know who the accusers are. In my case, the university hired a team of outside investigators, lawyers from another city who flew in to conduct an investigation. They would not give me the charges in writing. I did finally learn who the accusers were. We had a Skype session prior to me meeting with them. But so some of the procedures are very baffling, like why won't they give you the complaints in writing?
How could that possibly be legal? I mean, I get the sort of kangaroo court portion of this, and how this is all done outside of our legal system to me, it makes no sense whatsoever.
Yeah.
But when you're talking to these people, and then there's lawyers coming in from out of state and all this, what are they talking to you about if they are not telling you what you're charged with?
They ask a lot of fishing expedition sort of questions, and as I later talked to more people who've been through these procedures, that's the MO, is the fishing expedition question, and then things that you say, particularly if you're a male professor charged with some kind of potential misconduct, anything you say can lead to another avenue of investigation. And so people enter these situations, they don't know what their rights are. So like when the investigators said to me that I could not record the session, you don't know where these edicts are coming from. You just know somebody who seems to be an authority is telling you what you can and can't do. As I say, you don't know what your rights are, and you don't know what the consequences will be if you don't go along with it.
And when this is happening, is the entire administration just falling into line? I mean, is there anyone at the administration that was like, Laura, something seems wrong here, or you need a lawyer, or we should have someone defending you, or sitting with you, or counseling you, or anything?
Yeah, no, you're not allowed. I think every school makes their own procedures up. In my case, you were not allowed to have a lawyer in the session with you. When I met with the investigators, I could not have a lawyer there. I did consult with a lawyer on the phone before this, but I didn't want to spend a lot of money on this. I was a bit of a cheapskate. But, I will say...
But even if you had all the money in the world, it would still be absurd.
But professors are spending tens of thousands of dollars when, accused of something like having improper eye contact. I mean, some of the charges are so out there, but I've talked to people who have, just spent vast amounts of money consulting with lawyers, because of course now there's a huge industry legal industry and defending people caught in these situations. You know, it's a huge growth industry.
Right. Okay. So how did your case get to volition? How did it wrap itself up?
Well, it went on for 72 days. I met with these people who'd flown in, the investigators, for 3 hours or so. I was allowed to have a support person in the room with me, and I asked the guy who was the head of the faculty senate at the time to be my support person, which was not good because he later got brought up on Title IX complaints himself for speaking out at the faculty senate because he thought that, you know, what had happened was a violation of academic freedom.
And then through that, so he sits there with you, then defends you in another forum, and then he gets brought up on charges. Did I get that fully correctly?
That is right. But what you asked before about the administration, I mean, I didn't know who did know or who didn't know. I was told to keep this stuff confidential. So it was just very unclear to me what position I was in when I got this letter about the charges.
Yeah, and then not only that, but then you have a colleague offering counsel. Yeah. And then so the chill effect around this thing, it's like, why would anyone put their butt on the line to defend you or defend free speech or defend a professor's ability to teach the way they want if they know that they're going to be the next one because the preponderance of evidence is so low that they're going to be the next one caught?
See, in my situation, I did not feel like my job was at risk. I didn't have enough paranoia about the situation to think that my university would actually fire me for writing an essay. I thought that that would look very bad for them. So I felt somewhat, I didn't know what the outcome was going to be, but I didn't think it was going to be that I would lose my job. Whereas if I was a guy, a male professor, you know, or a student for sure, but a male professor accused of something that veered more toward sexual misconduct, I would have been far more worried in this situation. Right. And I should just say that, like, male professors in teaching situations that involve more personal contact with students, like, say, a dance instructor or drama, people, or even music, where you might touch a student, those people are hugely at risk. And I've heard about so many cases like that, where something that once would have seemed innocuous is now being charged as sexual misconduct or creating a hostile environment for a student.
Putting the legal part of this aside for a second, what do you think this is doing to the professors? So I get it if you're talking about a dance professor or an art teacher that may touch somebody as they lean over or whatever it is. But from those people all the way to just the regular professor that might fear that if there's a student that comes into their office and they say something the wrong way, or as you said, looks at them the wrong way, what do you think this is actually doing to academia in general right now?
I think the word is starting to get out that professors are really at risk of losing their jobs if there's any kind of controversy with a student. And people may not know that something like half the professoriate now is not tenured, meaning, you know, or tenure stream, meaning there's no job security. About half of professors now are kind of contract employees. This is the casualization of academic labor.
Oh, I didn't know that. So you mean not even on the track?
Yeah. No, they're hired as adjuncts or instructors on renewable contracts, sometimes one-year contracts. And those people, if they get caught in a situation where a student says that professor said something in a class that makes them uncomfortable, those people are out. Even if they're found not guilty, they are likely not going to be renewed. Or if there was a case just recently in the school of the Chicago Art Institute with a guy who was an art history professor whose some students accused him of like a textbook that he used they thought was racist. It was a book about comic book history, and the history of that period is about like racial imagery. So it was a book that was discussing racism in the history of comics.
Incredible.
So, there's many professors, I think, just are so fearful of getting caught in these situations that they're becoming very self-censoring, not teaching controversial subjects, being very careful about interactions with students. And I think also more and more male professors are really shying away from working closely with female students because the numbers of complaints about situations like that have risen. And I should just say, look, I have said I believe any professor that harasses a student, that is in proposes some quid pro quo arrangement, like, you know, a blowjob for a grade, I mean, those people should be fired. They should be out. There should be no toleration for that. But it's this sense of a student feeling uncomfortable in class about something somebody has said. Those sorts of cases, I think, are really just growing incredibly.
Right, and at the same time, just lowering the burden of proof in general is also just a horrific precedent to set.
Yeah, and because all of this happens behind closed doors, there's no oversight, and I think a lot of people in the Title IX field now have gotten a bit inflated with a sense of power because there are no checks and balances, there's no oversight, and so they are enlarging their sense of what sexual misconduct is on a kind of capricious, ad hoc basis. You know, so it's very much up to individual Title IX officers, or in the case of undergrads, like student deans, to decide what comprises an offense. And so I don't think that there's more sexual misconduct going on. I think what's defined as sexual misconduct is just like exponentially increasing.
Yeah, and that's what I want people to understand. If they take away anything from this, is that this system created a secondary legal system in effect.
Yeah.
I mean, that is simply not how the United States operates.
It is,
but I suppose,
at the moment, and people don't know this. Again, I mean, I feel like in my book I sort of was breaking news about the extent of this, because until it goes to civil cases, there's just no knowledge about what's going on.
And it sounds like it would be almost impossible to get that knowledge out because of the ridiculous system where it seems like nobody's accountable and you're not allowed to talk to people. You don't know what you've been brought up on. How do you even get this information out? And not every professor is going to be as forward as you and okay with still saying what they think and coming on shows like this and talking about it and all that.
Yeah, I think only 2 professors so far, other than myself, have gone public about cases against them because people are terrified of speaking out, and in fact are threatened that if they speak out they'll be charged with retaliation. And just in terms of Title IX generally, there's no aggregated, you know, set of data about these cases. I think we have no knowledge of how many cases there are, what the content of them is, except for the cases that have gone to civil court or settlements paid by insurers. There's some data about the cases by insurance companies.
So that's fascinating. So you don't even know how many, not only how many cases there are, but how many other people might be in your circumstance. So not people that have been accused of anything in terms of doing an action or having an inappropriate relationship with a student or any of that. There could be literally 500 other people like you that just wrote something in a vague defense of a faculty member or a vague takedown of Title IX that could be in your situation, and you just simply have no idea. It's incredible.
Well, so I think that, I mean, I weirdly have become a kind of data central by the virtue of people emailing me about their cases. So, I mean, I have an email inbox file of cases that I don't think there is other information about. And I don't, I mean, I included some of them in Unwanted Advances. I have a chapter called Fuck Confidentiality, or they're little asterisks. They are where I try to anonymize, is that how you say it? But go into as much detail as I can about some of the bizarre cases people have written to me about. Because after I did go public about my case, I'm not sure if I said, you know, I just got all of these emails from people about their cases. And I just would say that when I got this email saying I was brought up on these complaints, I had no idea if there were other professors who'd been charged over an article. I didn't know if this was a test case where, you know, it would expand the boundaries of Title IX. So I was just in the dark, and I didn't know who to talk to or to ask about it.
It's so interesting to me because I've had a series of guests on this show that have been in similar situations, either in academia or elsewhere, people that have been put in situations where they suddenly have to step into sort of a new light. Brett Weinstein, who I'm sure you're familiar with from Evergreen State, of course. Jordan Peterson up in Canada dealing with this. Even James Damore from Google. I mean, just people that are just saying what they think and then suddenly are thrust into the spotlight in a different way. So shifting a little bit, so then when Betsy DeVos last month basically said we're gonna turn back these Obama era regulations. You must have found this quite rewarding or vindicating, or what's another adjective I should use there?
Conflicted.
Oh, were you conflicted?
Well, I mean, I'm conflicted in that I am not a person who wants to have anything positive to say about the Trump administration. I mean, I, don't want anything to do with these people. But I did think DeVos was doing what anybody would do in that situation, which was to turn back what had happened under the Obama guidelines. I'm not sure it's going to make any difference on campus. I mean, there's been many, presidents, Title IX officers, people in positions of power have already said nothing is going to change on our campus to reassure the Title IX activists.
Wow, that's actually crazy, though. So the government, I'm not for all of these edicts that only the executive branch makes, but in effect, that's what Obama did. Now Trump reverses them, okay.
Yeah.
But you're saying that the schools now, because it's sort of like a hostage situation where they can't, if they've made it sound like this is the way it's supposed to be and this is what's right, they can't kind of backtrack on it. So they're going to keep in place, basically, is what you're saying.
Well, I think here in California, I'm pretty sure Janet Napolitano is the chancellor or president of the UC system, has announced that.
Wow, I didn't know that. I mean, that's incredible.
Yeah, to show that they're on the right side of things. So I don't know. One of the things that's happened is that there's been this incredible bloating of the administrative layers in universities, and these people are running the place. And there's such a vast infrastructure that's been put in place, you can't just dismantle that overnight. So I think part of the mission creep of all of this is that there are so many people whose jobs it is to weed out misconduct and prosecute it, to adjudicate it, that's not going away. So I'm not optimistic that the DeVos guidelines, even though they are saying they're going to have this advice and consent or advice and notice, whatever it is, period, that didn't happen with Obama under the Obama administration. They're trying to do it more procedurally this time around. But in any case, I don't see that it's going to filter down to the campus level.
Yeah, that's incredible. So how could it? I mean, if you were in charge right now, if you had DeVos's ear or Trump's ear or whatever it is, what would you tell them that actually needs to be done if just removing these additions isn't enough?
I actually think that, I'm maybe a cynic, that what's going to happen is that more and more cases go to civil court and will be decided against the universities, and that the general counsel's office in the universities are going to start overseeing what's happening more than they are. So it's civil court judges that are looking at these cases and saying, are you kidding? Could I just briefly talk about a case that's a really interesting one that came out of Brandeis? Because what was interesting, I mean, most of these situations at the undergrad level are heterosexual, but this was two guys, and two guys who were in a relationship and then broke up, and sort of 6 months later, one of the guys said that the other guy had kissed him while he was sleeping, and that was non-consensual sex because he hadn't consented to be kissed while he was sleeping. So Brandeis appointed some sort of special examiner. This was a Title IX charge. And the special examiner said, yes, the kisser was guilty of non-consensual sex because the other person hadn't consented. They kicked him out of school. So these are the kinds of cases that are, when I'm talking about mission creep or overreach. So the students sued Brandeis, and you have to have a lot of money to sue a university. It costs something like $100,000 and up to $1 million if a case goes to trial. So this went to a judge, and the judge said, are you kidding? This is what you're calling sexual assault, and found against against Brandeis. I may be getting some of the details wrong, whether it was simply dismissed or there was a judgment against Brandeis. But so it's the judges that I think are going to be creating that level of oversight and turning back these cases. And I think that might filter down, particularly as schools are starting to pay out settlements to accused students.
Yeah, that's incredible, because for me personally, I'm not someone that would want to, I think we have way too much over litigation here. But in effect, what you're saying is the only way to really combat this is you need students who've been improperly accused that have the resources to start bringing lawsuits, because eventually
Yeah.
the schools will realize we can't sustain this. We're taking
Yeah.
so many cases that actually don't hold
Yeah.
water,
Yeah.
and we can't keep doing this.
And professors as well. And I think there are a few, I've heard about some cases that professors who've been dismissed are suing universities too, but they haven't gotten as much attention. So I do think this is going to be played out in the courts for quite some time.
So is there a piece of this that's sort of obvious that I'm missing here? How does this not get to criminal court? If there was a case where it really involved not just a kiss when someone's sleeping, but if there was a case that really involved rape or being drugged or any of that, how is that not automatically a criminal offense? How does that even stay within the jurisdiction of this? It just doesn't even make sense to me.
Well, you know, one of the reasons that these guidelines and these processes move to campus is that at the legal level, you know, district attorneys weren't taking these cases to trial because in a lot of these situations there isn't evidence. The accuser comes forward much later, you know, so they either on an evidence level or whatever don't rise to the legal level. So they were prosecuted on campus because, you know, there was a lag or gap in you know, the legal systems dealing with sexual assault. So I understand that, or it would take, you know, years for a case to go forward. So part of the issue was to have a process in place that would rectify what wasn't happening off campus, to get these students, if there were aggressive, you know, usually male undergrads, you know, particularly serial offenders, you know, get them off campus. So those are some of the reasons that it wasn't handled at the criminal level.